Sorry, Patrice, for calling you earlier. Patrice Sulton is Executive Director of the DC Justice Lab. Good morning.
Good morning. Thank you, Councilmember Allen, for inviting us to this hearing and for co-sponsoring the Restore Amendment Act of 2021. Thank you, Councilmember Henderson, for introducing it. DC Justice Lab is extremely proud of this effort. It is the first bill that we developed since we started a few months ago, and it really is the first proof of concept we have for our theory of change. The fact that 8 council members immediately supported the language we drafted and 2 others expressed their enthusiastic support the following day demonstrates that we went about this the right way. We worked with as many people as we could, including returning citizens who have experienced hardship as a result of their criminal records, and also including more than half of the witnesses that you'll hear from today. I'll just share one of the things that I learned from those conversations that I hadn't really appreciated before. And that is when you have a criminal record and someone does give you a job, that employer may take advantage of the fact that they know it's hard for you to find another job. There was one young woman who was explaining that her boss terribly mistreats her and that he does that because he knows she's in such a difficult position and it's hard for her to leave that job and find another one with her record. As others have already mentioned, this is very much a racial justice issue. According to the Sentencing Commission's last report, 93% of the people sentenced in DC are Black. There's more information about the need for the legislation at dcjusticelab.org/sealthedeal. But I'd like to walk through the features of the Restore Act now and explain a little bit about how it changes district law. There were 3 main goals. The first was making more people eligible. The second was making it easier on everyone. We've heard a little about that already, but the litigants have a very difficult time in these cases, but so do the court staff and the agencies who are trying to interpret a very confusing current Chapter 8. And the third consideration was really safeguarding due process considerations. So there are certain reasons that a person would need to access their own record or that a prosecutor might need to share a record in another case, for example. So the only way to really address these 3 concerns was to wholly rewrite all of Chapter 8. And I don't think that you'll hear from anyone today who doesn't think that that's the right way to go about this. The current chapter is such a mess. So what we did here is to separate it into 4 different sections. The first section creates an avenue for actual expungement of criminal records. Sometimes people refer to actual innocence motions under our current 16802 as expungement, but a lot of agencies still have access to those records and it doesn't do what it says it does, which is to restore the person to the position they would have occupied before the arrest occurred. In contrast, the Restore Act includes a mechanism for records to be sequestered by the court only. This change is supported by other jurisdictions. According to the Collateral Consequences Resource Center, there are about 25 states that do not allow law enforcement to keep and use expunged records themselves. It does not require that the court fully destroy expunged records. Full destruction would make it impossible for people to retrieve records if they need them in immigration proceedings, for lawsuits related to their arrest, or for prosecutors to turn them over when they constitute exculpatory evidence in other cases. The second section defines criminal record sealing, and that's defined to mean that the records are kept in a non-public file by the court, prosecutors, and law enforcement, but not the other agencies that are included in current law. The third section explains when expungement can occur. It happens automatically for people who are convicted of an offense that was decriminalized, and it happens on motion for people who were not convicted of what they were arrested for or charged with. And the fourth section explains when record sealing occurs. It happens automatically for all non-convictions, and it happens on motion for convictions. The biggest change here is that it opens up criminal record sealing relief to everyone. It doesn't mean that you automatically or necessarily will have your record sealed if you file very quickly, or if the offense is of a nature that the court thinks even more time is needed before they want to grant record sealing relief, but it gets rid of the barriers that exist in the current law and gives everybody not only an opportunity, but an incentive to build a record that it's in the interest of justice to give them a fresh start. We'd also like to note that the council should pass the Criminal Record Accuracy Assurance Act of 2021, which was introduced separately, and we'd be happy to offer suggestions on how that bill can be made stronger. And in closing, I just want to emphasize that we really need this to happen this year so that as DC reopens, the 1 in 7 people with a publicly available record have a chance to compete. I'm not sure there will ever be another opportunity like this to sign a piece of legislation that you know when you're signing it will mean someone gets a job, will mean someone gets a home who otherwise wouldn't. Thank you again. I look forward to your questions.
Thank you very